Greetings from Nairobi, Kenya. Karibuni sana to Diaspora Voice, your weekly TV show that focuses on issues affecting Kenyans in the diaspora. We've been away for some time now and we're back reviving at full throttle. I'm your host, Joy Doreen Bira. Now, all eyes are on Kenya's Supreme Court and observers across the globe are keen to see how the six-judge bench will handle the presidential poll petitions. In this episode of Diaspora Voice, we focus on the petitions before the Supreme Court and the six judges who will deliver the landmark ruling. To start us off, here's a story about the implications of the petition by our senior reporter, Erin Acheng.
The ramification of the court petition that was filed Saturday at the Supreme Court is historic and may have a greater bearing in the country if at all the case is won by the petitioner. One of the grievances that court presents is the widespread manipulation of numbers during the tallying of votes, and this could mean that the entire process could be found illegitimate. If the Supreme Court finds grounds to believe this, then it might mean a ruling that could nullify the whole process and a penalty to IEBC.
In the event, then the court also finds the commissioners or some of the commissioners to be liable for conducting a redundant election, then that becomes very challenging, because eventually I don't think the players in the election, in case a fresh election is declared by the court, the players would want the same commissioners to handle an election.
If the voter register is found to be wanting, then it will present problems of a bigger magnitude, as a fresh voter register will have to be in place before the elapse of 60 days after the ruling. The electoral body will also have to use all instruments available to safeguard the credibility of the poll outcome. This includes biometric voter registration and identification, as well as electronic voter transmission. If it so happens that a ruling of such a nature is made and IEBC is found guilty of conducting a sham exercise, then it might lead to a series of other petitions from other poll losers, even if time for the petition will have expired. According to constitutional experts, the courts may have to be asked to give a constitutional interpretation of the ruling that may lead to cancellation of other results if challenged in court.
Other contenders who have lost in the just concluded general election will also have a basis upon which to challenge the outcome of and the declarations that were made by the IEBC insofar as their election is concerned. So this is going to be something that will have a very big magnitude.
Court has already indicated that they have a strong case against the election of Uhuru Kenyatta and William Ruto, and have severally indicated their faith in the current court system headed by Willy Mutunga.
Sasa Wakenya wataona vile demokrasia itatetewa mbele mahakama na ukweli itajulikana.
In the event that the judiciary rules in our favor, we shall be ready to run from day one. In the event that they rule any other way, we are ready to go back to the people.
Jubilee, on the other hand, is already reaching out to other presidential candidates and has so far backed the support of a money coalition headed by Musalia Mudavadi. This presents a picture that should fresh presidential elections be called by the Supreme Court and those who are already dining with Uhuru choose not to run, then it will be a clear two-horse race with advantage Uhuru.
As the president of the court mandated to resolve the presidential poll dispute, Chief Justice Willy Mutunga is the man of the moment. Most people know him as the head of the judiciary, but what we don't know is that Chief Justice Willy Mutunga has spent 3 years behind bars. Rita Tinina takes us through the prolific journey of the Chief Justice to the highest court in the land.
With the clock ticking on the 14-day constitutional deadline for the Supreme Court to hear and determine the presidential election petition, the spotlight is firmly on the 6 Supreme Court judges. 5 men and 1 woman who will make a ruling on the precedent-setting case challenging the declaration of Uhuru Kenyatta as the winner of the March 4th polls. As president of the highest court in the land, 65-year-old Dr. Willy Mutunga is a man under sharp focus. Described by some as a reform activist, Mutunga began his activism while serving as a law lecturer at the University of Nairobi in the 1970s. He and other academics formed the university staff union in 1972. In 1979, just months after Daniel Moi took over power, Mutunga became the Union's Secretary General. His campaign to have controversial author Ngugi wa Thiong'o given his university teaching job back landed him in trouble with the KANU regime. Mutunga was arrested in June 1980 and was accused of being a member of the December 12 movement. 2 years later, in June 1982, he was charged in court for being in possession of seditious material and was detained just days before the abortive August 1, 1982 coup. After 3 years and 4 months in prison, Mutunga was released in October of 1983 and went into exile in Canada. Willy Mutunga, who had before his incarceration obtained a law degree from the University of Nairobi and a master's degree from the University of Dar es Salaam, used his time in exile to pursue his doctorate of law from York University in Toronto. Even as he studied, he continued pushing for reforms back home. Together with other exiles at the time, such as Kiraitu Murungi, they launched the Kenya Human Rights Commission. In 1992, Mutunga, who was then among a group of pro-democracy activists such as Paul Mwite, James Orengo, Kiraitu Murungi, Raila Odinga and Gitobo Imanyara, became the chairman of the Kenya Human Rights Commission as his fellow reform activists joined politics. He was later to serve as chairman of the Law Society of Kenya from 1993 to 1995. During his tenure, the LSK was seen as a formidable voice compared to the then divided opposition. Mutunga spearheaded an initiative of the LSK, the Kenya Human Rights Commission, and the International Commission of Jurists to draft a new constitution despite resistance from the then government. The 4Cs, Citizens Coalition for Constitutional Change, was born in January of 1995, but did not realize its goals after the then President Daniel Moi declined to negotiate constitutional reform with the civil society. In 1997, the constitution reform agenda was taken over by the Inter-Parties Parliamentary Group. Behind the scenes, Mutunga worked on opposition unity. In 2002, he convened a breakfast meeting of Mwai Kibaki, Kijana Wamalwa and Charity Ngilu, the then leading opposition figures. The talks led to the formation of the National Alliance for Change, which later merged with KANU rebels under LDP to form the National Alliance for Rainbow Coalition, NAC. Mutunga declined an offer to serve as the chairperson of NAC, saying he was not interested in joining politics and only wanted to unite the opposition. In April 2003, after NAC won the 2002 election, Mutunga declined an appointment to the University Council of the Jomo Kenyatta University of Agriculture and Technology, saying he did not have the right qualifications for the job. A year later, he joined the Ford Foundation as a Human Rights Program Officer. In 2009, he became the Executive Director, a position he held until May 2011 when he was shortlisted and later vetted for the position of Chief Justice. He was appointed Chief Justice in June 2011. Dr. Willy Mutunga has spearheaded reforms in the judiciary, which has been working hard to rebuild its image. But the historic presidential petition will provide the supreme test for the highest court in the land.
And with the exit of Nancy Baraza last year, the Supreme Court was left with only one Lady Justice. Here's a brief profile of Lady Justice Njoki Ndungu.
First, progressive
Supreme Court judge, lawyer, women rights activist Njoki Ndung'u is perhaps best known for her crusade on sexual offences, children and women's rights. The 47-year-old, who was nominated to Parliament by the National Rainbow Coalition in 2003, was the architect of the Sexual Offences Act. She was also behind the successful enactment of the Maternity and Paternity Act of 2007. Her crusade in Parliament may have been informed by her studies and her previous work engagements. Njoki Ndungu holds a bachelor's degree in law from the University of Nairobi, a master's of law degree in human rights and civil liberties from the United Kingdom, and a diploma in women's human rights from the World University Services, Austria. The soft-spoken Supreme Court judge began her career at the Office of the Attorney General as a state counsel in 1990. 3 years later, she moved to the Institute for Education in Democracy, where she worked as a program officer in charge of civic education. In 1995, she became the protection officer for the United Nations High Commissioner for Refugees. Her next employer was the Organization of African Union. She worked for the OAU as a political analyst until 2002, when she shifted gears to politics and started working behind the scenes with teams that were crafting opposition unity. After NAC won the 2002 election, she took her campaign for women's rights to the floor of the House following her nomination to Parliament. During the 9th Parliament, she served on several departmental committees charged with legal affairs and administration of justice. Aside from the Sexual Offences Act, Njoki Ndungu played a key role in the constitutional review process. She was in the Parliamentary Select Committee on Constitutional Review and was also a member of the Committee of Experts that drafted the new constitution. And her efforts on women and children rights did not go unnoticed. In 2006, she was named by the United Nations as the UN Person of the Year. In the same year, she got the Jurist of the Year award from the ICJ and was awarded the Elder of the Burning Spear honors by President Mwai Kibaki. Now sitting in the Supreme Court, Njoki Ndungu is the first nominated member of parliament and politician to sit in the country's highest court. From state council, refugee protection officer to member of parliament, she too knows dealing with the landmark presidential petition will be a totally different ballgame.
Respected among fellow judges for his long and dedicated service in the judiciary, Philip Tunoi is among the 6 who will determine the presidential poll petitions.
From the High Court, Court of Appeal to the Supreme Court, Justice Philip Tunoi Kimwetich is a man who has risen through the ranks in the judiciary. After graduating from the University of East Africa in Dar es Salaam with a Bachelor of Law degree in 1970, he started off as an advocate in early 1971. Thereafter, he became a provincial state counsel for Nyanza and Western provinces. He served as state counsel until 1973, when he ventured into private practice. For 13 years, he focused on his job as an advocate, but his career in the bench was just about to begin. In 1987, Justice Tunoi was appointed Judge of the High Court. He served as High Court Judge for 6 years before he was elevated to the Court of Appeal, then the highest court in the land. He served as an appellate judge until his career in the judiciary got another boost when he was appointed Judge of the Supreme Court in June 2011. But his appointment to the Supreme Court was not with a mere stroke of the pen, as had been the case when he was picked as Judge of the High Court and Court of Appeal. He was among 25 judges who were interviewed for the position of Judge of the Supreme Court. And that was not the only test he passed. The second most senior judge of the Court of Appeal, he survived the vetting by the Judicial Service Commission, which vetted judges on their suitability to continue sitting in the Court of Appeal in line with the new constitution. Justice Tunoi, who also holds a Master of Arts in Philosophy from the University of Nairobi, is the Vice President of the East African Court of Justice. He has made rulings in all manner of cases, including one in the year 2000, in which, as an appeal court judge, he ordered a husband to take back his HIV/AIDS infected wife. The ruling was seen by HIV/AIDS activists as setting a good precedent. At the Supreme Court, Justice Tunoi has been part of several landmark rulings, including the verdict on the application of the gender role and the election date. But for the long-serving judge, the presidential election petition is like nothing he may have come across in his 26 years on the bench. The petition will provide a legal dilemma of its kind for him and other Supreme Court judges.
Justice Mohammed Handar Ibrahim bounced back to the Supreme Court bench in September 2012 after successfully challenging a decision by the Vetting of Judges and Magistrate Board to axe him from the bench. The vetting board had declared Ibrahim unfit in July 2012, a year after he was appointed to the Supreme Court in June 2011. Until then, Justice Ibrahim had been a High Court judge serving in Eldoret, Nairobi and Mombasa since his appointment on May 22, 2003. He obtained his Bachelor of Laws degree from the University of Nairobi and was admitted to the roles of advocates on January 11, 1983. He practiced law at Messrs. Waruhiu and Muite Advocates, where he was admitted as a partner in 1985. In 1994, he established Mohammed Ibrahim and Associates, which subsequently expanded to Ibrahim and Isaac Advocates, partnering with Ahmed Isaac Hassan, currently the chairman of IEBC and the first respondent in a petition to be determined at the Supreme Court by Ibrahim, among other Supreme Court judges. He has served as a council member of the Law Society of Kenya and a board member of a non-governmental organization, the Legal Education and Aid Program, LEAD. Justice Ibrahim was actively involved in civil rights advocacy at the advent of pro-democracy movement in Kenya. The judge was arrested and detained during the Moi era without trial in 1990 in the run-up to the Saba Saba pro-democracy rally at the infamous Kamkunje grounds for engaging in subversive activities aimed at undermining and overthrowing the government. He was arrested alongside the current Prime Minister Raila Odinga and others for plotting an anti-government rally. The Prime Minister now set to appear before him in a petition seeking to overturn the election of Kenya's fourth president. The detention would later shape Mohammed Ibrahim's philosophy. The judge remarked that the arrest and subsequent detention made him appreciate the meaning of liberty and inspired him into championing the liberation movement and a just society. Justice Ibrahim's tenure has been riddled with a lot of controversy stemming out from some of his judgments. In November 2010, sitting as a Mombasa High Court judge, Ibrahim terminated a piracy case against 9 Somali pirates arrested in the Indian Ocean high seas on grounds that the Kenyan courts lacked jurisdiction to deal with matters that had taken place out of Kenya's territorial waters, instead ordering the government to repatriate the suspects to Somalia. Ibrahim would later be bashed for his decision that would later be overturned by the appeals court. Coincidentally, Ibrahim serves under Chief Justice Willy Mutunga, equally a former detainee and comrade in the pro-democracy movement then. Kenyans are sharply focused on the Supreme Court judges as they await a landmark ruling on the election petition to be delivered by, among other judges, Mohammed Ibrahim.
Well, next week we will continue to profile the Supreme Court judges. Following the mention of the petition on Wednesday, President-elect Uhuru Kenyatta, his deputy-elect William Ruto, and IEBC Chair Isaac Hassan gave their official responses to the petition. Here's a summary of their reply.
The 3 petitions involving the declaration of Uhuru Kenyatta as President-elect were mentioned before all the 6 judges led by the Chief Justice Dr. Willy Mutunga.
The court is now fully seized of the petitions challenging the presidential elections. Towards this end, the petitioners and the respondents, their agents, supporters, and advisors are directed to desist from prosecuting the merits of their cases in any forum other than this court.
Uhuru Kenyatta, William Ruto, and the IEBC chairman Ahmed Isaac Hassan have filed their responses, which are similar in many instances. They all accuse Raila Odinga of having a history of refusing to concede defeat in elections since 1997. But the responses are also unique in some areas. Uhuru Kenyatta has insisted the election was free, fair, and credible, carried out by the IEBC according to the law, despite numerous technical challenges. He has dismissed Raila's claim that the IEBC bought faulty BVR and electronic voter identification equipment, saying Raila as Prime Minister played a key role in the acquisition of the equipment. Uhuru also says there is no law that forces the IEBC to use electronic transmission of results, neither is there a law forcing them to use electronic voter identification at the polling stations. He insists there is no evidence given by Raila to show the voter registers were tampered with. As for Raila's accusation that a company called Kencol gave Jubilee an unfair advantage by hosting the servers of both TNA and the IEBC, both Uhuru and Ruto say TNA and Kencol are not parties to the current petitions and should not be mentioned. Uhuru says Raila Odinga is only out to create a constitutional leadership crisis so that he can negotiate his way into the government again. William Ruto in his response says Jubilee won the election with over 50.02%, but insists that the Supreme Court has no jurisdiction to decide whether the IEBC committed a crime in the way they conducted the elections. He also says the Supreme Court only has the power to rule on the validity or otherwise of the presidential election and not the procurement processes for the biometric voter registration kits or the electronic voter identification kits. He also says Raila Odinga has no right to call for the nullification of the entire general election because it would affect senators, governors, MPs, women representatives and county ward representatives who have not had a chance to defend themselves in the Supreme Court. Ruto says, as the Prime Minister, Raila had the powers to stop any pre-election maneuvers or government conspiracies that he considered were planned to disadvantage him in the election. He also reiterates that Raila has never accepted defeat in previous presidential elections. He wants Raila's challenge against the integrity of the IEBC commissioners and personnel dismissed because he says Raila participated in the recruitment and vetting of the IEBC top officials. The IEBC chairman, Ahmed Isaac Hassan, has also filed his response, insisting the election was conducted according to the law. He pleads with the Supreme Court to consider the potential harm to the public interest if the entire election is nullified. Hassan says Raila cannot complain now about the voter register because he was involved in the process and did not complain earlier. He has also dismissed Raila's criticism of the procurement of the BVR systems, saying it was the government of Kenya that procured the machines through Raila's office and therefore it was Raila's own undoing. Like Ruto, Hassan says Raila has always rejected election results since 1997. He says it is unfair for Raila Odinga to use the court petition to try and get a second chance to have a go at the presidency after the March 4th election. The bench that will hear all the three petitions has not yet been constituted. It could be all the 6 Supreme Court judges. It could be just the 5 minimum required by the Constitution, but that will be revealed at the pre-trial conference on Monday, the 25th of March, when all the parties meet here again ahead of the beginning of the hearings proper in this presidential election petition. My name is Noah Otieno at the Supreme Court in Nairobi.
And now we will take a short break, and when we return, we will move to the United States of America, where we'll be joined by Chris Wamalwa, our U.S. host.
The first time I remember when I got to the airport, I was like, wow, like my face felt so frozen and my fingers, and I'd wear like 3 jumpers a day.
One of the things I really miss about being in the US was the independence. You could do whatever you want, you could go to work, you could earn your own living, you can have your own car.
So many Kenyans who are in the diaspora, and all these Kenyans at the end of the day, they're gonna go back home.
To anybody who is trying to come back to Kenya, who has been, like me, living in another country their whole life, whether Australia, UK, yes, it will be a big adjustment.
We want to have power to be able to choose who to be our best leader.
Diaspora is the goose that lays the golden egg, and it keeps laying more and more eggs.
The diaspora in America sends to Kenya every year 80 billion Kenya shillings.
From Kenyan politics, we now move on to the U.S. immigration matters, and our U.S. host, Chris Wamalwa, has more from the United States.
Thank you. Today we've lined up a show that tackles immigration issues in the U.S. We host Regina Ndungu, who is an immigration lawyer based here in the U.S. She gives us an update on the Obama administration's efforts towards dealing finally with the issues of immigration. But before we do that, I asked Regina the question, what are the implications of Kenyans abroad not being able to vote in the elections? And this is what she had to say.
So that means Kenyans in Kenya, who are Kenyan citizens, born in Kenya, equal citizens, same caliber of citizenship as the Kenyans in the diaspora, have an absolute right to vote, while Kenyans in the diaspora have a limited right to vote. In my opinion, that's a question of discrimination and equal rights. There is no justification for discriminating Kenyans in the diaspora by giving them a lesser right to vote as opposed to Kenyans in the homeland, while the status of their citizenship is the same.
But Regina, based on this, even this, when you look at the clause on dual citizenship in the new constitution, many people are just surprised that it limits so much when it comes to the diaspora. For instance, I can't go home and contest some seats. Is the problem within the constitution as it is? And if that's the issue, what is it that we can do to change that?
Yes, I think throughout the constitution, when our diaspora issues are addressed, there is clear and blatant discrimination of Kenyans in the diaspora. The reason for that is probably the fact that the diaspora was not involved in coming up and fashioning these laws, or rather we did not lobby for our interests. So because we did not lobby for our interests, then the laws that were passed were not in our best interests. And unfortunately, the laws have been passed. So what we can do right now is lobby to change the laws. And as you know, just getting an amendment to the Constitution is an uphill task. So the diaspora will have an uphill task in trying to get amendments to the Constitution and also other laws that discriminate against Kenyans in the diaspora.
The same issue about progressive rights was the same law that they used to deny the women the quota that was allocated to them in the Constitution. Does that also fall within the discriminatory nature of our laws within the Constitution?
I totally agree. There's a trend of discrimination against minority interest groups, and that would include women and the diaspora. And maybe in future we'll see other cases coming up where there will be discrimination against, e.g., the disabled people and other interest groups. And that just underscores the need for the stakeholders and those affected by these laws to be vigilant and make sure that this does not happen.
Going forward, because it's a done deal, in terms of moving forward, what do you think the diaspora can do to change some of these discriminatory laws within the Constitution?
In my opinion, I will echo what Mkawasi and the ambassador, His Excellency Elkanah Odembo, said, that we need to come together and we need to stick together. We also need to exercise our muscle in terms of, for instance, the fact that we are contributing significantly to the Kenyan economy through our remittances. Now, if we were to withhold our remittances, that would bite. We have to exercise our rights in terms of pushing and putting pressure on the government. I think for a long time, the Kenyan politicians have treated diaspora Kenyans with disdain. They actually, in my opinion, feel threatened maybe by what we could do in terms of if we were to go run for public office, and that's why they put all these limiting provisions, limiting diaspora Kenyans from running for public office, and we need to stop that.
Regina, just following up on that, what you said, one of the things that I've realized as I go to Kenya and as I get involved in the issues of the diaspora is it's not just only the politicians that don't take the diaspora seriously. Even the Kenyan masses, when Kenyans hear about the diaspora, the first thing that comes to their mind is that they left. So what stake do they have in the country? Is it something that we failed to make our case? And if that's the case, what can we do, again, to change the perception that we don't really deserve what is rightfully ours?
I think there's a misconception in the minds of the Kenyan public, and the politicians included, that when you leave Kenya, you are actually abandoning your country, and that's not the case. Most people that leave Kenya and go to the diaspora usually are coming to the diaspora to look for greener pastures and to look for more economic opportunities. And Kenyans in the homeland and politicians should realize that even when we come here, we remain Kenyans, because that's why we are sending all that money back to Kenya, because we have a vested interest in our country. But again, we Kenyans in the diaspora have failed to pass that message back to the Kenyans in the homeland. When we go to visit, maybe the way we behave, the message we send sends other signals. For instance, some people go to visit and they let their relatives know, well, I have bought a house in America, I'm going to be in America or in the UK or in Denmark to stay. Then you're creating an attitude within the people you're dealing with that you're not going back to Kenya, or you have left and you have abandoned your ties, and that should not be the case.
Regina, let's come back home and talk about you being one of the few immigration lawyers that we have here in the diaspora. Obama was re-elected, and basically issues around minorities, more specifically about on immigration. Right now, everybody in America, the government and the different parties are engaged in looking at ways in which they can deal with the whole issue of comprehensive immigration. One thing that is clear is that when they talk about immigration in America, they are talking about Latinos. It's like we don't have issues with immigration as Africans. What do you think we can do to be a part of the conversation that is going on around immigration as a community?
Well, Chris, I'm very glad that you asked that question. I just wrote an article 2 days ago that on the internet about that issue. Right now, as you know, the president has embarked on pushing for comprehensive immigration reform. This initiative had begun previously, but it died in the tracks just because it was too controversial during the last term of Obama's presidency. But right now, this is the right time to get a comprehensive immigration reform passed. And why do I say that? I say that because both parties, the Republicans and Democrats, have a vested interest in seeing that there is comprehensive immigration reform. The Democratic Party, because they want to reward the Latino voting bloc for bringing them back to office. And the Republicans, because they're trying to lure the Latinos into their party because of the bruising defeat that they suffered during this last election. And they realized that the demographics are changing. And in fact, one thing they realized, unless they reach out and quote the Latinos, which is a formidable voting bloc, they are going to continue losing in future elections. Now, as far as African immigrants are concerned, there is this distinction between African immigrants and Latino immigrants. And I explained that distinction very well in my article. Most of Latino illegal immigrants tend to be undocumented, and most African illegal immigrants tend to be documented. Now, undocumented immigrants refers to those immigrants who the U.S. government have no record of their presence in the United States. Why? Because they cross the border through Arizona, Texas, or California. They are not inspected. Nobody has a record of their entry. Now, documented immigrants refers to those immigrants who get into the U.S. Using some kind of a visa. It could be a student visa, F1, or a B2 visa. They have to come through a designated entry point, usually an airport. All U.S. airports that receives international flights are designated entry points. So when you come in from, let's say, Kenya, Nigeria, or other countries, you come through an airport. And as you know, you have to be inspected by a Customs and Border Patrol agent, CPB agent. So once you're inspected, then they have a record. You get an I-94, a record of arrival. That means you're documented. Unfortunately, the government would not have a record of your departure when you depart, because you're not required to give in your I-94 when you depart. And even if you do, most people usually would have lost them, so they don't give them in. So that's the difference. Now, the Latino lobby groups are more concerned with the interest of the undocumented immigrants, who are the Latinos who cross the border. And that leaves the fate of the documented immigrant unaddressed, because there is no lobby group for the documented immigrants. Now, any immigration reform that has passed in the past that has benefited the documented immigrant It has done so incidentally because of the efforts of these Latino lobby groups. As an example, the DREAM Act that everybody talks about and everybody is excited about, including Kenyans and documented immigrant Africans, there was a misconception that this DREAM Act was going to cover documented immigrants. I personally, when it started, thought it was going to cover all immigrants, only to find out late after the bill had been debated and it was going to pass into law that it expressly exempted documented immigrants. In particular, those immigrants that came here as F1s and fell out of status would not be covered under the DREAM Act.
Is that true?
That is very true. And the reason why that provision was in the DREAM Act is because there was nobody lobbying for the documented immigrants. So there is a need to lobby for the documented immigrants, or there is a need for us as documented immigrants to join forces with the Latino lobby groups, not only benefit from their efforts after they've put in all the sweat, they arrange all the demos, they do all the placards, they walk around, they make all the noise, and then we just end up benefiting as a by the way. We need to get involved.
But that's something that I've really raised in the past, because unfortunately when it comes to our people, especially the African community in the US, when you mention the word immigration, and if you call a meeting, for instance, to come and address immigration issues, you'll hardly see anybody. Or the people who will come are the people even who have the papers, because there's still that fear within us that when you show up just like this, you're exposing ourselves. That's one of the reasons why Kenyans in the US are not even registered with our embassy, because they fear that when they register with the embassy, that information is likely to even land in the wrong hands. Again, moving forward, as a community, Regina, can you outline to us the kind of steps that we just need to take to come out of this? Because that's an issue that we can't just let it go like that.
Yes, Chris, I will definitely agree with you. There is an unreasonable fear of immigration authorities by Kenyans and maybe other African immigrants. I have been an immigration lawyer for 7 years plus now. And every day during my practice, I have learned that the immigration system in this country is a humane system. And I have said that time and time again. Just the fact that your information is known by immigration authorities and they know that you're illegal, they're not going to come after you. I have had clients and people that I know, for instance, I have even gone to court with people that do not have papers. They have passed through the security line and inspected by Immigration and Customs Enforcement agents. And we have disclosed to these agents that they are here illegally, and they've been allowed to go to court, sit and follow the proceedings of their friends and their family, and they live safely and they are not followed. So it's not a fact that just because immigration knows you're here illegally, they'll come after you. Their priority is on criminal illegal aliens. They have a priority list. They go after the criminal aliens and the fugitives. Everybody else, they will leave you alone. They know you're here, but they will leave you alone.
Regina, before we open up the discussion to the audience, let's talk briefly about the Obama. What's the relief that he gave to young people? What is it called again?
Deferred action.
Deferred action. As a lawyer, do you see many Kenyans taking advantage of that provision to register and benefit from that clause?
Oh yes, I think in my experience, everybody that I have come across that have children or because they have to be under 16, so they are still minors. They have applied for it. It's going very smoothly as long as they don't have a major criminal record. You could have a minor criminal record. For instance, in Maryland, DUI 1, DUI number 2 is not major. They will let you go. If you have that DUI or there are other aggravating circumstances, then it becomes an issue. They're approving them left and right. They want these people to stay here because they think it's only fair that they stay here. That's why I'm saying the immigration system is humane. So they want them to stay here. They know they're here illegally. They want to help them work. I deal with immigration and custom enforcement officials, deportation officers every day, and I would talk to them even after an order of deportation has been entered by an immigration judge. We are still able as lawyers to reach out to immigration and customs enforcement and persuade them, please do not deport my client because they have an illness, they need to stay here and be treated, or for other reasons. And they will grant the waiver. They will let them stay for as long as it takes for them to get treatment or other circumstances that may be facing. So that's why I say they are fair.
My name is David Amakobe and I live here. Regina, thank you very much for addressing the immigration issue. I have a question about the reason. About a week ago, President Obama signed the waiver, the law that allows people now who either are here because they are here illegally, but they have either family connection, either an American child, American spouse or something like that, to apply for a waiver so that when they go back, they can go back to their country and apply for a visa and come back. I have a feeling that I know that President Obama has very good intentions to make sure that he cuts the number of illegal immigrants here. But coming from you as a lawyer, I think I would like you to address that so that any Kenyans who are here illegally can know that that's a good thing for them so that they can go and apply for it so we can reduce the number of people without documentation here who have already attachments here. Because originally you had to go step outside before you apply and you are not sure whether you could be able to come back. But with the president this time have signed that law that allows within a certain window so they can apply for the waiver. When they are still here, they know whether it's allowed or not, and when they get it, they go back to the country, apply for a visa. Can you address that? I would appreciate that. Thank you.
Yes, thank you. First, I would like to say that the question of immigration waivers is a very technical one. And also, just you realize that that regulation was just signed a week ago. So the details of the regulation are not known to most of us. I will tell you that I have not had a time to study in depth what the waiver is about, but I know about the proposal that led to the waiver. Now, what will happen in the past? What had to happen is that they are called 212 waivers. For instance, if you're barred, if you're out of status, and if you've been out of status and you have what they call the 10 and 3-year bar, then if you went, you'd have to apply for the waiver at the consulate. Now, the new regulation changes that. Instead of applying at the consulate, you apply for the waiver here. And once it's approved, when you go abroad, you're going to get your visa within 1 week instead of the previous system where people had to wait about 2 years and it was not automatic that they would get a visa to come back. Now, as to whom these waivers apply, the regulation still has to be explained and expanded and put into forms. As you know, when you're dealing with immigration, everything you do with immigration has to be done through a form and a fee. You have to fill a form and a fee. That's how it operates. They have not yet taken out the forms that needs to be filled. But in brief, again, it's a good thing because you get the waiver here, you don't have to get it at the consulate as previously, and then it's a more easier system than it was before. So it makes it easy. It's actually what the regulation was about, was a humanitarian kind of gesture to bring families together, because under the old system, families were separated for such a long period of time, and this is meant to close that gap. And you mentioned that President Obama is determined to reduce the number of illegal immigrants in the U.S. That was during his first term because of the politics that were prevailing at that time. But I'm telling you, with the second term, what I see is a President Obama who is so committed to addressing the needs of the immigrants and the illegal immigrants in particular, that he has made it actually one of his first priorities, second to the fiscal cliff. So the writing is on the wall. I am I could vouch for this 100%, but nothing in life is certain other than death and taxes. I'm only going to say this. It's almost a guarantee that we are going to see comprehensive immigration reform this year.
Thank you, Chris, for that piece. We look forward to having more of these and so many other stories from the United States and across the world. The Diaspora Voice team would love to hear from you. Send your questions and comments to the email at the bottom of your screen. And if you would like to take part in the show, send us an email with your details and we will get back to you. Now, we've come to the end of our show this week, but we will be back with more next week, so do care to join us. Our Twitter handle is Diaspora Voice. And of course, you can also look out for us on our KTN Kenya Twitter handle. I'm Joy Doreen Bira with the Twitter handle @Joy Doreen Bira. Until next week, God bless and see you then.